Galle start. Like I think last time discussed about the directors and secretaries. Then go on to our next topic. That's very important topic. That is about company meeting. Company meeting. So, right now, our next topic is meeting. So we can identify there are two types of meeting. Board meeting. So we can say directors meeting. And the second one is members meeting. Another name, general meeting. So we can say EM, general meetings. Right? Members meeting. Right. So shareholders meeting. In this topic, actually, we are going to discuss about the members meeting, right? Not about the. When we consider the members meeting, or general meetings, there are two types of general meetings: AGM and EGM. Right? Annual general meeting. Extraordinary general meeting, EGM. Annual general meeting and extraordinary general meeting. There are two types of members meeting, general meeting. Now, first we can consider the annual general meeting. Right? Each company must hold an AGM, annual general meeting, once in each calendar year. Right? Once in each calendar year. When we consider the duration of AGM, right? Say, now, if it is a newly incorporated company, incorporated company, then after incorporation within 18 months, 18 months. This company must hold its first AGM. Right? This is the first. First AGM. After incorporation within 18 months. Right? This newly incorporated company must hold its first AGM. Right? Then, thereafter, right? In each calendar year, this company must hold AGM, right? Annual general meeting, right? So, right after the first AGM, like the first AGM, AGM to AGM, right? AGM, AGM to AGM, right? AGM to AGM, maximum period can be passed is 15 months. 15 months. Right? Or we can say the maximum period can be passed between two successive, right? AGMs is 15 months. So simply we can say AGM to AGM 15 months. Right? This is in regard to the first AGM. Then thereafter, AGM to AGM maximum period can be passed is 15 months. And another condition, that is, right, not later than 6 months after the balance sheet date. Right? After the balance sheet date, balance sheet date, after the balance sheet date, right? Not later than 6 months, right? Or we can say within 6 months. So these are the conditions to be followed by the company in order to hold its AGM. And after the first AGM, then thereafter company has to comply with these two conditions. AGM to AGM maximum period is 15 months. And the second condition is, right, not later than 6 months. Not later than 6 months after the balance sheet date. We can consider after the balance sheet date, within, right, after the balance sheet date, cannot hold the AGM prior to balance sheet date. After the balance sheet date, but within 6 months. Not later than means within 6 months. That is the second requirement. So two conditions to be fulfilled. Understood? Right, so there are two conditions, right? Remember, there are two conditions. People. So AGM to AGM 15 months, right? And after the balance sheet date, but within 6 months, right? Not later than 6 months. After the balance sheet date, within 6 months. Right? So the company must hold its AGM. Right? If the company now this is compulsory meeting, right? In each calendar year, company must hold an AGM, right? So AGM, annual general meeting, right? Or like AGM. Right? If the company defaults in calling AGM, then what may be happen to the company? Right? Company shall be guilty of an offense, right? If the company defaults in holding AGMs, annual general meeting, company shall be guilty of an offense. It is treated as an offense. It is treated as an offense. Then, on conviction, right, the company, right, are responsible to pay a fine. Fine. Right. Not exceeding 100,000 rupees. That's the punishment given to the government. And every officer who is not following the AGMs, right, shall be guilty of an offense on conviction, right, be liable to pay again fine officers. Conviction, be liable to pay a fine, not exceeding half of this, right, 50,000 rupees. That is the punishment given to the officer who are not comply with the provisions contained in the Companies Act with regard to AGMs. Right? So there is the compulsory requirement mentioned in the Companies Act, right? AGM with regard to AGM. Right now, when we consider these two, right now, suppose we can consider one example, right? Right now, suppose a particular company, right? This company hold its AGM for 2025 on 15 May. Right? Balance sheet date of the company is 31st of March. In each year, right? Balance sheet date is 31st of March. Right. Right. In the last year, this company, right, held its AGM on 15 May. Right. Then within how much of time or what is the duration for the AGM in this company for 2026? 2026. Right. Calculate that. The last AGM is on 15 May 2025. Balance sheet date is 31st of March. Then what is the duration of the AGM for 2026? Current issue. Yes. Balance sheet date is 31st of March. 31st of March 2026. Right. We have to comply with two conditions. AGM for 2025 held on 15 May. Right. Balance sheet date is 31st of March every year. Right. Then duration, we have to calculate the duration for AGM 2026. Yes. AGM to AGM, maximum period can be passed is 15 months. Right? Therefore, 15 August. Right? 15 August 2026. Then after the balance sheet date, but not later than 6 months. Right? So when we consider 6 months, that is 30th September. Right? 30th September. Right? Yeah. I'm not here. President here. Right? So from here to here, 6 months. From here to here, AGM to AGM, 15. And within, so what is the duration for AGM in 2026? They have calculated. Yes. So we have to consider that within which period both conditions are fulfilled. Right? This is the orange color, this is blue color. Like both conditions are fulfilled during period. Therefore, what is the period after, like after 31st of March 2026, right? Or no before. No before. Further, 15 August 2026. So during this period, this company must hold its AGM for 2026. Understood? Right? Now, they cannot hold AGM here, right? It's more than 15 months. AGM to AGM maximum is 15 months. Right? They cannot hold AGM here, right? Because according to the second condition, after the balance sheet date. After the balance sheet date, but not later than 6 months. Therefore, during this period, after 31st of March, 2026, or no before 15th August 2021. During this period, this company must hold its AGM. In other words, we can identify both conditions are fulfilled during this period. Lines, right? And consider cost during the period, right? After 31st of March, no before 15th August. Right, so that is the period for 20 AGM for 2026. Right. So two conditions to be fulfilled, right? Then yes, it is a compulsory meeting, right? If the company defaults in holding its AGM, it is an offense, right? Then the company shall be guilty of an offense on conviction. Company be responsible to pay a fine not exceeding 100,000 rupees, and every officer shall be guilty of an offense on conviction, be liable to pay a fine not exceeding 50,000 rupees. That is compulsory meeting. Right. Then another very important thing is now here the company has to call a meeting. Right? Before calling the meeting, company must give notices to the shareholders. Right? Company must give notices to all the shareholders of the company. Notice of AGM. Very important. Notice of AGM. So in order to call an AGM, right, every company must give not less than 15 working days notice. Right? Not less than 15 working days notice. Right? We have to consider only the working days. Therefore, Sundays, Saturdays, public holidays, right? All the holidays we have to exclude, right? Not less than 15 working days, right? Working days notice to be given. That is the requirement with regard to the AGM, right? Notice of the AGM. So before calling AGM, right? Every company can give not less than 15 working days notice. However, suppose due to particular reason, the company unable to give not less than 15 working days notice to its shareholders. Then by short notice, right? This company can call an AGM. Right? Instead of 15 working days notice, by short notice, company can call an AGM. Right? However, in order to call an AGM, right, by short notice, than 15 working days notice, right? Very important thing is all the shareholders must give their consent to call the meeting by a short notice, right? Our company can call AGM with consent of all the shareholders. All the shareholders. With consent of all the shareholders, company can call an AGM by short notice than 15 working days notice. Understood? So with consent. Therefore, they have to find a resolution, right? By giving their consent, right? They have to sign a resolution to call an AGM, right? By short notice, that 15 working days notice. Then thereafter they can call the meeting. Then it is permitted. It is there according to law. Right? So this is the general situation. Generally, in order to call an AGM, not less than 15 working days notice. Then requirement. Right? However, company can call an AGM by short notice instead of 15 working days notice. But in order to call an AGM by short notice like this, then all the shareholders must give their consent. They must agree. They must agree. They can sign a written resolution by giving their right willingness or right their approval to call the meeting by a short notice. All the shareholders means 100% shareholders that must agree to call the meeting by a short notice, right? Otherwise, company cannot call, right? AGM without giving, right, 15 working days notice. Right? With consent of all the shareholders, 100% shareholders, right? They must give their consent to call the meeting by a short notice. Now here, another thing is now shareholders, all the shareholders means, right? These shareholders, they are entitled to attend the meeting and vote, right? Vote at the meeting. So these shareholders, right, consent to be taken in order to call the meeting by a short notice, right? Shareholders who are entitled to attend the meeting, general meeting, and vote. They have the voting power. as a right at the general meeting. Right. So these shareholders must give their consent to call the meeting by short notice. Reason is in some cases we can identify some shareholders, they don't have voting power. They are unable to attend meetings, general meetings. Right? Which type of shareholders cannot attend general meetings? Now, there are several categories of shareholders we can identify. Yes. Some shareholders, they don't have these rights. Attend the meeting and vote at the meeting. Yes. Now, generally, we can specify the shareholders ordinary and preference. Preference shareholders. Right. So, ordinary shareholders, actually, they are the real owners of the company. So, we name them as equity shareholders. Ordinary shareholders. Generally, they are entitled to attend the meeting and vote. They are the real owners of the company. Right? Preference shareholders, they have the preference for receiving dividends and being paid out the capital in the event of liquidity. They have the preference. We get a Maramian for us, right? They don't have, generally, they don't have things like attend the meeting and vote at the general meeting. Right? They have the preference for receiving dividends, right? That is, before paying the ordinary shareholders, company must pay for the preference shareholders. In the event of liquidation, right? In order to pay the capital, right? Priority to be given to the preference shareholders. They have the preference for receiving dividends and capital in the event of liquidation. Therefore, we name them as preference shareholders, right? Preference shareholders. So here actually shareholders mean, right, the shareholders who are entitled to attend the general meeting and vote at the general meeting. They must, all the shareholders must give their consent to call the meeting, right, annual general meeting by a short notice. That is the reason, right? So that simply we can consider, right? Now here, in order to call an AGM, right, not less than 15 working days notice to be given. Right? However, short notice is permitted, right? All the shareholders, right, give their consent to call the meeting by a short notice than 15 working days notice. So actually here, shareholders means shareholders who are entitled to attend the meeting and vote at the general meeting. They must give their consent. Again, there is no harm to the company because all the shareholders give their consent for the meeting, right? By short notice. That is the requirement. Understand? It is about the notice of AG. Then I told you there are two types of meetings. There are two types of general meetings. EGM and EGM. Right? Now we can consider the EGM, extraordinary general meeting. EGM. General meeting. Now, this one is extraordinary general meeting, EGM. EGM very simple, that is every meeting, right? Every general meeting other than AGM. Right? Every meeting other than AGM is named as EM, extraordinary general meeting. Right? General meeting. Every general meeting, shareholders meeting other than EGM. Right? Every general meeting other than AGM, annual general meeting, right, is treated as an EGM, extraordinary general meeting. The company has to hold EGM. Yes. What is the reason? Now, AGM is once in each calendar year. Once in each calendar year, that is AGM. EGM, because of urgency, right? Company cannot wait until next AGM in order to make a decision. In order to make a decision, company cannot wait until next AGM. So immediately, company must hold a members meeting. Therefore, EGMs are called. That's the right. The main objective of the EGM, right? Because of emergency situation, and we're unable to wait until next AGM, right? Immediately, company call shareholders meeting, right? So this meeting is named as an EGM, extraordinary general meeting. Then the next important thing is, now in order to call an AGM, not less than 15 working days notice to be given. If it is an EGM, extraordinary general meeting, then before calling the meeting, right, private company, public and other company. If it is a private company, not less than, right, again not less than 5 working days notice. Not less than 5 working days notice to be given. Right? If it is a private company. If it is a public and other companies, right, they shall give not less than 10 working days notice. 5 and 10. Right? In order to call an EGM, right, private company shall give not less than 5 working days notice, right? And public company must give not less than 10 working days notice. 5 and 10, right? In the private and public companies, respectively, right? So that's the requirement. Notice of AGM. So EGM, notice of EGM. This is the requirement. In private company, not less than 5 working days, right? In public company, not less than 10 working days notice to be given. Right? The notice to be given, then thereafter, they will hold the meeting. They will hold the meeting at a particular place. They will hold the meeting. Right. Now, here we have discussed the short notice is permitted if all the shareholders give their consent. But here also say, like instead of 5 and 10 working days notice, like private and public company can give short notice, right? Short notice, right? In order to call an EGM, the short notice can be given in private and public companies instead of 5 and 10 working days notice, right? So here, in order to call an EGM by short notice, then 5 and 10 working days notice, right? Not less than 95% of shareholders. 95% of shareholders must give their consent. That is the requirement. Not less than 95% of shareholders must give their consent. We must agree. Right? Now we can compare, right? With regard to AGM, annual general meeting, all the shareholders must give their consent. All the shareholders. Right? But here, not less than 95% of shareholders. 95% of shareholders must give their consent. Not all. 95% of shareholders. Again, shareholders who are entitled to attend the meeting and vote at the general meeting, right? So, must give their consent, right? Not less than 95% of these shareholders, right, must give their consent to hold an EGM, extraordinary general meeting, by a short notice. Right? Short notice that 5 and 10 working days notice. Understand? Now, when we comparing with the AGM, actually this is not a compulsory meeting, right? Because of the necessity, company will call an EGM. And due to an emergency, right? And they unable to get the next AGM, company will call an EGM. Therefore, this is not a statutory requirement, calling an EGM, right? Because of the necessity, all the company will call an EGM. But when we consider the AGM, it's a compulsory requirement. Once in each calendar year, company must hold an AGM, annual general meeting. But this is not a compulsory meeting. Right? Now, this is the requirement, right? AGM and EGM. And I think is next thing is actually when we consider the EGM, 3 parties can call EGMs. One is directors can call EGMs. Right? Directors. Right? Tell me one example, directors call EGM. We have discussed about directors. Yes. They can convene or call an EGM. Directors can call an EGM. Tell me one example. We have discussed about under duties of the directors. We have discussed. Either director. One example. 3 parties can call shareholders, directors, and court. Right? Court can call an EGM. Right? So, if the company call extraordinary general meeting, if it is not practicable, then court can call EGM. One example for directors, they can call EGM, extraordinary general meeting. Yes, one example here, right? When we consider the duties of the directors, like 2 main duties, right? One is duty on solvency, right? Duty on solvency, right? Duty on insolvency, sorry, insolvency, right? What is the duty on insolvency? It is named as insolvency. What is the duty on insolvency? Yes. So, insolvency means unable to settle debts, right? If a director came to know, right? The company cannot pay its debts in its ordinary course of business, then immediately, director must call this type of meeting. I told you there are two types of meeting. Right? Board meeting and general meeting. Right? And the duty on insolvency, right? If the company, the director came to know that the company unable to pay its debts in its ordinary course of business, right? Immediately, no time, promptly, right? The director must call the board meeting. There is board meeting. Right? That is the duty cast on the director. Right? Immediately he must call board meeting. And another duty we have discussed, duty on serious loss of capital. Serious loss of capital. Okay? Serious loss of capital. That is net assets of the company. Serious loss means serious loss. Loss of capital. Serious loss of capital means, right, net assets. Net asset. The value of the net assets of the company is less than half of the stated capital. Net assets. Net assets means total assets. We have to deduct liabilities. So when we consider the balance sheet, total assets 100, liabilities 30, 40. Is then half of the stated capital. Stated capital. So this is the situation in the company. When we consider the balance sheet of the company, we can identify this type of situation in the company. If there is a serious loss of capital, like net assets 60, less than half of the stated capital. Stated capital 140, then half of the stated capital 7. So here we can, yes, like we can identify serious loss of capital. What is the difference? It is minus 80. Minus 80. Minus 80 means loss, accumulated loss in the company. Loss, accumulated loss. Right. So this is the serious loss of capital. Right. If a director came to know, right, that the company has a serious loss of capital, then within 20 working days, right? Time period given, 20 working days, director must call. Right? Within 20 working days, director must call and EEA. Extraordinary general meeting. There is a duty. Extraordinary general. It's a general meeting, shareholders meeting. Right? Under insolvency, board meeting. Board meeting means directors meeting. Right? No time given, promptly must call directors meeting. That is the duty. Duty on insolvency. This is duty on serious loss of capital within 20 working days, time period given. And which type of meeting? Shareholders meeting. EGM, extraordinary general meeting. Right? Shareholders meeting. Unable to wait until next AGM. Right? Actually, here EGM is calling to explain the financial situation to the shareholders of the company. That is the main purpose of this calling EGM. Right? To explain. Right? The company has to explain the financial situation to the shareholders. So, in order to explain it, like within 20 working days, director must call an EGM. So directors can call an EG, like shareholders can, board can call, like directors, then shareholders, they can call, and the board can call, like extraordinary general meetings. Right? Remember this one. Serious loss of capital. And the duties of the company, they two duties. Duty on insolvency, duty on serious loss of capital. Right? If it is insolvency, directors meeting. No time period given. Immediately call directors meeting. That is the duty of the director. Right? Serious loss of capital means, right? Actually, we can summarize this, right? Serious loss means accumulated loss in the company. Accumulated loss. Okay? After director came to know about this, right? Within 20 working days, time period given, within 20 working days, right? Director must call general meeting. This general meeting, EGM, extraordinary general meeting. Right there. Only two general meetings, AGM and EGM. You cannot call annual general meeting. Annual general once in each calendar year. So I'm able to wait until next AGM, EGM, extraordinary general meeting to be called. That is the duty of the director. Right? I mean, they don't want to say, they don't want to right. So, this is about the AGM and EGM. It's simple. And board that renovating a balance. Getting a mother and notice of AGM, 15 working days notice to be given. Short notice, permitted. Right? Under AGM, all the shareholders must give their consent to call the meeting by short notice. EGM, right? Notice of EGM in private company not less than 5 working days notice. Public and other companies shall give not less than 10 working days notice. Here also short notice is permitted, right? With consent of not less than 95% of shareholders, right? Both company, private and public company can call PG by short notice, right? Instead of 5 and 10 working days notice. Right? That is the requirement, right? And there's another point, right? Now it is related to next topic, right? That is now the company called an EG. Right? Why actually meetings are called? Why shareholders meetings are called? What for? Any racing can because you need a car to handle it. And what is the meeting like? Why meetings are called? Share directors meeting and shareholders meeting. Why they are called meeting? In order to make decisions, right? They make decisions. තීරණ ගන්න. අදලා තීරණ ගන්න. ඔබ දැන් කරන්නේ නේ. මේ ප්‍රශ්නයක් තියෙනවා. ඔබ ගන්න. In order to change the name of the company, the decision to be taken. In order to make the decision, a meeting to be called. At the meeting, they can make the decision. Right? At the meeting, shareholders can make the decision. In order to remove director, now we have discussed about the directors. In order to remove director, the decision to be taken. Right? So, in order to make that decision, the meeting, shareholders meeting to be called, because the power is given to shareholders to remove a director by passing an ordinance resolution. I told you, a director can be removed, right? So in order to make that decision, we need to be focused. Very simple, right? So actually, when we consider the decisions, so right, there are two types of decisions. We name them as ordinary resolutions. Now, another name we can consider decision. Decision means instead of decision, instead of this word, this term, we can give another term, resolution. Another word. Resolution means decision. Right? Resolution. Resolution में क्या है? तीर हम मत करेंगे तो तीर में तब है resolution. Right? Resolution. तो तीर है resolution. So there are two types of resolution. There are two types of resolution. Ordinary, special. Ordinary and special. Ordinary and special. Right? In an EGM, in this extraordinary general meeting, suppose the company is going to pass special resolution. This type of resolution, special resolution. Then both companies, private and public, both companies shall give not less than 15 working days notice. Then 5 and 10 is not permitted. Right? In an EGM, right? Private or public company is going to pass a special resolution. Right then. Right? Both companies shall give not less than 15 working days notice. 15 working days notice. That is the requirement. Right? Then 5 and 10, it is not permitted. Not less than 15 working days notice to be given. Then actually this exemption is not applicable. Right? With regard to passing special resolution. In an EGA, right? Not less than 15 working days notice to be given. Actually now, the company actually need not to comply with this requirement, right? If they are going to pass a special resolution, they are going to put a without the penalty. So that is the output that they have. Now, right? In private or public company, in an EGM, extraordinary general meeting, right? If the company is going to pass a special resolution, then not less than 15 working days notice to be given instead of 10 months. It is not permitted. If not less than 15 working days notice to be given. Okay, but there's an exception given, introduced under the special resolution. Reason means, right? Reason is there are two types of resolution. Right? Two types of resolution. Ordinary, special. Special resolution means in order to pass a special resolution, two conditions to be fulfilled. There are two conditions. One condition is not less than 15 working days notice to be given. That is the right. The reason for not less than 15 working days notice to be given, right? In order to pass a special resolution in an EGM, right? Because right, in order to pass a special resolution, right, two conditions to be fulfilled. One is not less than 15 working days notice to be given. Right? Not less than 15 working days notice to be given. Right? Therefore, in an EGM, extraordinary general meeting, the company is going to pass a special resolution. Then, right, both companies, private and public companies, shall give not less than 15 working days notice. Right? Because of the right special resolution. Conditions introduced under special resolution. But you can put them in a scenario. In the general situation, right? General, not less than 15 working days notice to be given. But then the effect of one. With the consent of 95% of shareholders, right? Instead of 5 and 10 working days notice, they can give a short notice. Short notice. Right? I told you, generally, in order to pass a special resolution, then not less than 15 working days notice to be given. Then under special resolution, we discuss. Even if the Companies Act says special, in order to pass a special resolution, not less than 15 working days notice to be given, there is an exception. An exception. Under this exception, right? What are the there is an exception. Under this exception, actually need not to give not less than 15 working days notice. Right? Even if less than 15 working days notice given, company can propose and pass the special resolution under this exception. This is the general situation, right? Now, AGM doesn't matter. Already given 15, not less than 15 working days notice. AGM, under EGM, right? Extraordinary general meeting, right? In order to call an EGM, extraordinary general meeting in private company, not less than 5. Public company, not less than 10 working days notice to be given. Right? However, in an EGM, if the company is going to pass a special resolution, then not less than 15 working days notice to be given. Because in order to pass a special resolution, at least 15 working days notice to be given. In order to pass a special resolution. Therefore, in an EGM, extraordinary general meeting, if the company is going to pass a special resolution, not less than 15 working days notice to be given. This is the general situation. Right? However, in consent of right, 95% of shareholders, instead of 10 and 5 working days notice, right, they can give the short notice. Take a hurry. We got a Colombo, we got a couple of other special research. Again, parallel in order make a become a keyword, make a ring and put it out. Take an exception. Parallel did not make parallel notice. Did not make. For these ring and full of master, very difficult to pass a special resolution under that exception. This is the general situation. Generally, not less than 60 days notice to be given in order to pass a special resolution in an EG, extraordinary general meeting. Right. Right. So this is about the meetings, right? AGM, EG. Right. Then there are we can go on to we have and we can go on to resolution. Resolution is decision, right? At a meeting, shareholders and directors, they are making decisions. Now we are going to discuss about the resolution passed by shareholders, right? In general meeting. General meeting. Right now, resolutions. Resolution means decision. Shareholders can make decisions, right? By there are several things, right? First one is at a meeting. Basically, three things at a meeting. At a meeting means general meeting. General meeting. They can make decisions. Right? At a meeting, they can pass three types of resolutions. There are three types of resolution. Ordinary, right, special, and unanimous. At a meeting, right? At a meeting, three types of resolutions can be passed. Ordinary, special, and unanimous. Yeah. Then the second type is, right, without a meeting, the second is no meeting, we don't call a meeting, right? Without a meeting by way of written resolution, right? By written resolution. So very important area, right? By way of written resolution without a meeting, no meeting, right? Here, no meeting, no here, general. We not call a meeting. Other way, company can sign a written resolution, right? By written resolution, another way, it is applicable only to the private companies. Third way, by unanimous agreement. It is applicable only for private companies. Only for private companies. Unanimous agreement. And this is unanimous resolution, right? At a meeting, unanimous resolution. This one is unanimous agreement. Right? Actually, this one we have discussed between other types of companies we have mentioned unanimous agreement. In a private company, there is special feature that is an agreement in writing, signed by unanimous means all the shareholders, all the shareholders. An agreement in writing signed by all the shareholders, company can make any decision, even though it is not compliant with the provisions contained in the articles. Right? But one condition, company must meet solvency test. Right? If the company able to meet the solvency test, right, then by way of unanimous agreement, they can engage into any type of transaction, even though the transaction is not compliant with the provisions contained in the articles. Understood? We have discussed that. So here, an agreement in writing. Agreement in writing. Signed by all the shareholders. All the shareholders. So it is named as unanimous agreement. Only applicable to private company. We have discussed that in this. And the types of company. Unanimous agreement. So by this way, we can make decisions. Unanimous agreement. We can make any decision, even though it is not compliant with the provisions contained in the articles. Right? But only thing is they have to meet the solvency test. What do you mean by solvency test? Solvency test. I believe solvency test. Very famous question. Amadama there are two conditions. Right? In order to meet the solvency test, two conditions to be fulfilled. What is the meaning of solvency test? Right? On the whole of the office, first one is we have to check whether the company has good working capital. Working capital. Very short term. Right? Ability. Working capital. Working capital. And the second one is we have to check whether the company has reserves. Reserves. Right? Working capital and reserves. The company able to meet the solvency test. Working capital and reserves. Companies act again. Counter like a our whatever how both in the Negri they watch an put a Tarama kind of set. First time, first test is we have to check whether the company is able to pay its debts. Pay its debts in its ordinary course of business. Whether the company is able to pay its debts in its ordinary course of business. That is the working capital. The company has good working capital. Day-to-day business, is the company able to pay its debts? That is the right phase. Right. Whether the company able to pay its debts in its ordinary course of business. The space. And the partner because serious loss of capital. Right. The second phase, reserves of value of the total assets. Value of the total assets is greater than right stated capital. Stated capital plus liability. Right. So there is the second phase. Right? Stated capital. Sorry, total value of the total assets greater than stated capital than liability. Now, suppose this is the balance sheet, total assets 100, right? Stated capital 50, right? Liabilities 30. Right? Here, total assets 100 greater than stated capital 50 plus 30. Yes. Right? Altogether 80. 30 is greater than 80. Right? So here the balance is plus 20, right? 20. So that is reserves. Not minus, but in period loss of capital minus, right? Balance is minus. That is accumulated loss. But here reserves, right? Or profits, accumulated profits or reserves. Same. So this is the test. Right here, total value of the total assets greater than stated capital and liability. Right. That is the test. Our terms we can say reserve. Working capital instead of able to pay states in its ordinary course of business. In our, according to our terms, we can it has working capital. Whether the company has good working capital, right? And whether the company has reserves. That is the thing, right? So if the private company able to meet the solvency test, then by unanimous agreement, they can engage into any transaction. But even if the transaction is not comply with the articles of association. Transaction is against the provisions contained in the articles, but that's not a private company can engage into that transaction. It is able to meet the solvency test. Right now, we can consider at a general meeting, shareholders meeting, there are 3 types of resolutions can be passed. Ordinary, special, and indemnity. Right. The first thing, right? First one is ordinary resolution. This is a resolution which is passed by simple majority. Simple majority of votes. Simple majority of votes. The resolution which is passed by simple majority of votes. Right? It is named as an ordinary resolution. Ordinary resolution. What do you mean by simple majority? Right? Simple majority as a percentage. Simple majority means as a percentage. Simple majority. Sarala bahutara here for 1 second. Majority. 1 second. 50 or 51. Sarala bahutara. Simple majority. 50 or 51. 51 more than 50. More than 50. More than 50. More than 50 means not 51. More than 50. There is not 51. Right? 50.001 also more than 50. No 51. But it is more than 50. Right? There is the right. As a percentage, we can say more than 50. Need not to get 51. Need not to get 51, right? More than 50. Right? 50.001 also more than 50. That is enough. Right? So by majority of simple majority of votes, right? The solution it is passed by simple majority of votes. That is named as ordinary resolution. An ordinary simple majority of votes. So we can say more than 50. More than 50. Right. Special resolution. Now we have discussed. Right. Special resolution. This is a resolution which is passed by a majority of 75% of votes. At a meeting, right? So this one also at a meeting. At a meeting. Here also at a meeting. Right? Majority of 75% of votes. The resolution which is passed by majority of 75 votes, right? After giving not less than, right? This is the second condition. I told you there are two conditions to be fulfilled in order to pass a special resolution. After giving not less than 15 working days notice. Right? So, if it is a special resolution, then we have to consider two conditions. A resolution which is passed by majority of 75% of votes at a meeting, right? After giving not less than 15 working days notice. Right? So before passing the resolution, propose and pass the resolution, not less than 15 working days notice to be given. Right? This chapter, right? That the company is going to pass a special resolution like that. Right? So, which type of decisions to be taken by passing special resolutions? Yes. Simple majority, right? So we have to consider about the seriousness of the decision, right? If it is a serious decision, then special resolution to be passed. Otherwise, the company cannot make that serious decision. Now, when we consider according to section 92 of the Companies Act, it says in order to amend the articles. And the articles of association. Special resolution requires. Special resolution requires. Right? Amending name. Change the name. Name of the company. Another very serious one. Special resolution requires. Right? And another situation, amalgamation. Approve amalgamation. Special resolution requires. Company is going to amalgamate with another company, right? Merge with another company. Then special resolution requires. Right? Then that is not under section 93. Another yes, under 93, another situation recognized, that is approve major transaction. Approve major transaction. Major transaction. In order to approve major transaction, special resolution required. Special resolution. Major transaction. Major transaction. Another very important concept. Major transaction. Now, when we consider this balance sheet, right? Total asset funded. Total asset. The value of the total asset is funded. Value of the total asset is funded. Major transaction means value of the transaction. Value of the transaction is of the transaction. Yes. Right. Value of the transaction is greater than half of the total assets of the company. Then the transaction is named as major transaction. Value of the transaction is greater than half of the total assets. Half of the total assets of the company. Now, suppose the company is going to engage into transaction with another party, value of the transaction is 60. Right? Value of the transaction is 60. It is greater than total value of the total assets 100, half of the total assets 50. So this is a major transaction. Major transaction. Therefore, it's a highly risky, right? Highly risky transaction. The value is greater than half of the total assets of the company. Therefore, in order to approve this type of transaction, special resolution required. Special resolution required. Major transaction. I give a Samaga. Good day, I'm not good. Garaduma, maybe I'm not good. It was very right. The value is so high, right? When we comparing it to total assets of the company. Therefore, in order to approve this type of transaction, special resolution required. And another situation is in order to reduce the stated capital, that is named as reduction of stated capital. Reduction of stated capital. The company has to pass a special resolution. The company is going to reduce the stated capital. And so these are the situations recognized in the Companies Act. Right? But we have to consider the Companies Act as well as the Articles of Association. If the article says in order to make particular decision, special resolution request, then we have to comply with the Articles of Association. Right? Then if there is no specifically mentioned special resolution request, all the decisions can be taken by passing an ordinary resolution. Now, in order to remove a direct ordinary resolution in a simple majority of votes, right? With consent of simple majority of the shareholders, we can remove a direct of the company. Right? By passing an ordinary resolution, the company can remove the direct and other business transactions, right? Apart from major transactions, can be taken by passing simple majority of votes, by passing ordinary resolution. Right, so we can, when we consider these instances, we can recognize these are very serious, right? When we compare with the transactions with the company, because the main the articles means articles of association, the main fundamental law, right? The constitution of the company is going to amend a serious matter. Then change the name. Name is very important. Right? Name of the company is very important. Right? Yeah, it's a serious matter. Change of the name. Right? Approve major transaction because of the value. Very serious one. Approve amalgamation. Company is going to amalgamate, merge with another company. Serious matter. Major transaction. Right? Reduction of stated capital. Right? So these are very serious matters. Then special resolution required. Right? Here, more than 50, this is by majority of 75% of votes, and after giving not less than 15 working days now. Two conditions to be fulfilled. They are not going to go back and have to buy it. After giving not less than 15 working days now. It is mentioned in the Companies Act. That's why we have to mention it. Right. But here actually no notice period mentioned with regard to the ordinary resolution. There's no. Here it says not less than 15 working days notice. Notice period is mentioned there, but here there's no notice period mentioned. It's special, sorry, ordinary resolution. Only one condition we have to consider at the meeting, like by simple majority of votes, company can pass an ordinary resolution. Then unanimous resolution means actually all the shareholders, 100% of shareholders give their consent for the resolution. Unanimous resolution. The Companies Act doesn't say which type of decisions can be taken by passing unanimous resolution, but it may be mentioned in the articles of association. Right? Actually, when it is recognized as a type of resolution under Companies Act, but examples, instances are mentioned under ordinary, not actually ordinary. Instances are mentioned under only special resolution in the Companies Act. Right? In the Companies Act, it has mentioned like section 92, right? In order to make these decisions, special resolution requires. Right? But there is no such provisions in the Companies Act with regard to ordinary and unanimous resolutions. Right? Then we have to go through the articles of association of the company. So according to the articles, if it is required to pass a unanimous resolution, that is all the shareholders consent, right? In order to make a decision, then we have to comply with the articles of association. Right. Another misconception is, now here it says more than 50, right? By majority of 75, here all means 100. 55% of, right? How we calculate this 50%? More than 50. More than 50. Yes. How we calculate more than 50? The method, we can identify two situations. Right? When we consider the company and at the meeting, right? 50 requests from when we consider the shareholders of the company, shareholders at the meeting. Then 50, how we can calculate from the shareholders of the company or shareholders at the meeting. 75 shareholders of the company, shareholders at the meeting. All the shareholders, unanimous resolution, all the shareholders of the company or all the shareholders at the meeting, at the general meeting. From which we have to calculate 50, 75 and 100%. Passive, Samagami no that at the meeting, we are 50 at the meeting, 75 at the meeting, all the shareholders at the meeting. Right? After giving notices, all the shareholders of the company need not to attend the meeting. Even in their order, like it carries a meeting or in the better. And about that, the maximum can hold the meeting. Right? So, in order to proceed after holding the meeting, in order to proceed the meeting, there shall be minimum number of shareholders present at the meeting. The company can proceed the meeting. I know that the given Malay man. Of the Patan Mao, then all the sun can have the same Pataka. Doesn't matter. Right? Okohai man. He will get a What is the minimum number of shareholders to be present in order to proceed the meeting? That is named as quorum. Quorum here. Quorum. Quorum क्या है गणपूर्ण पश्चिम पटांग है गणपूर्ण है पार्लिमेंट की गणपूर्ण तीनों का है अधिक कोई आवनाव वैसे पार्टी है अवध संख्या बताओ ना बड़ी पटांग है they can make the decision. They can proceed the meeting. Quorum. Quorum make a fulfill lunana, they can proceed the meeting. So it is right manner. What is the quorum? If it is a private, right? Two shareholders. Quorum is two shareholders. Public, three shareholders. That is the quorum. Quorum is minimum number of shareholders to be present, right? In order to proceed the meeting, in order to proceed the general meeting. So, if it is a private company, two shareholders enough. Minimum two shareholders present, the company can proceed the meeting. Only one, they cannot proceed. Right? If it is a public company, minimum three shareholders must be present. The company can proceed the meeting. Unanimous resolution. Special resolution, all the shareholders must be there. This month is representing 33. Then we must make out 66 maybe, right? So all the share. Other than on 3 shareholders, we can right? 15 years, right? They make out again. Okay, public company. 2 minute they make everything ordinary. They can pass the ordinary resolution. That's so unanimous came make a type. Special resolution make a type. Of course, have a 2 minute after the minute from the yeah, quorum is fulfilled. Minimum number is okay. 4 shareholders present at the meeting. The public company. Right. Then ordinary resolution means 2 shareholders. With their consent. Right. And special resolution means 3 shareholders. Right. By majority of 75%. Unanimous. All the shareholders. With consent of all the shareholders, they can make the decision. Right. Right. Quorum. Right. Not the shareholders of the company, right? Not the shareholders of the company, we have to right. Shareholders at the meeting. That's why we are sending notices to the shareholders with regard to AT and ET. Right? It's a compulsory requirement. Sending notices to the shareholders of the company. Right? We check around.
You can have additional papers to prove the examination. Take out. How do you take it? How do you have it? Take the book camera. Mama, namaste. Namaste. Apa dah itu?
Oye, va a tener video, no sé qué va a tener.
Yo no voy a traer para que no ya. Football saya football dia tak dia sama kita balik football
Right now, under special resolution, this is a resolution passed by majority of 75% of votes after giving not less than 15 working days notice. Right? However, there is an exception. This is the exception I mentioned. There is an exception. According to the exception, actually the company needs not to give not less than 15 working days notice. Right? Even if less than 15 working days notice is given, the company can propose and pass. Right? Propose and pass the resolution as a special resolution. Right? However, under this exception, percentage, right, it will increase. Right? Here it says under exception by majority of 85% of votes at the meeting. Right? %85. Right now, under special resolution, there are two conditions. In order to pass a special resolution, by majority of 75% of votes at the meeting, right, after giving not less than 15 working days notice. Two conditions to be fulfilled. Right? However, right, an exception introduced to the this special resolution. Right? Under exception, company needs to give not less than 15 working days notice. Right? Even with less than 15 working days notice given, company can propose and pass a special resolution. Right? The company's action 143 section 143, it says, right, company can propose and pass a special resolution even if less than 15 working days notice is given by majority of 85% of votes at the meeting. Right? Company can propose and pass the resolution as a special resolution. Therefore, now, yeah. Right. So I told you in an EGM, right? In a private company, 5 and working days notice to be given, right? But in an EGM, the company is going to pass a special resolution, right? Then not less than 15 working days notice to be given. But according to the exception, right? Right, actually, under this exception, company need not to give, right, not less than 15 working days notice. Even if the company has given less than 15 working days notice, right, by majority of 85% of votes, company can propose and pass a resolution as a special resolution. That is the exception. Understood? Right? Therefore, actually, this is the general situation. Generally, less than 15 working days notice to be given. But in special situation, actually, even though the company are able to give the less than 15 working days, not less than 15 working days notice, company can, at the meeting, company can propose, right, and pass a resolution as a special resolution. Right, by majority of 85% of votes. There is the right exception. Understand? General situation and special situation. Generally, right, 75 plus not less than 15 working days notice to give. But on the exception, right, percentage is 85%. I need not to give not less than 15 working days notice. That is the exception, right? So it is introduced in the exception is introduced to the special resolution. Right. So now yes, ordinary resolution, simple majority of votes. Again at the meeting, like all resolutions at the meeting. Special resolution by majority of 75% of votes plus not less than 15 working days notice, but under this exception, right, company need not to comply with the second condition. Even with the less than 15 working days notice given, company can propose and pass a resolution by majority of 85% of votes. Right? Unanimous means at the meeting all the shareholders give their consent. Right? And that is unanimous resolution. So these are the resolutions can be passed at a meeting. Right? Call the meeting at the meeting. Right? Three types of resolutions shareholders can pass. Right? Ordinary, special, and unanimous. Right? Now the second method, no meeting, no general meeting. Company needs not to call a meeting, right? By way of a written resolution, company can make any decision, right? It is valid as if it is passed at a general meeting. Same validity given to written resolution, right? So here, written resolution. This is a resolution. Right? A resolution in writing. Right? A resolution in writing signed by right? A resolution in writing signed by shareholders, right? Not less than signed by shareholders not less than 85%. 85%. Right. So this first condition is with regard to persons. Persons. Right. It is a resolution signed by not less than 85% of shareholders. Shareholders are the It is a resolution in writing signed by not less than 85% of shareholders. Shareholders. Persons. Here persons means, now here shareholder means, right? Shareholders of the company. Right? Shareholders of the company. So no meeting code here. Right? Not less than 85% of shareholders of the company. Right? Shareholders of the company. Right? Connecting word is very important. And Right? Two conditions to be fulfilled. And the resolution in writing signed by not less than 85% of shareholders of the company. And who together holding these shareholders together holding not less than 85% of voting rights. Right. So second condition is with regard to voting right. The balance sheet, right? Balance sheet. Voting power. These shareholders together holding not less than 85% of voting rights. Right? Right. So by this way, right, the resolution in writing signed by not less than 85% of shareholders persons and who together holding not less than 85% of voting rights, that company can make any decision. Right? They can take any decision. Right? It is valid as if it is passed at a general meeting. The same validity given to the resolution. Right? Same validity given to the resolution. Right now, this is very technical task. Right now, suppose now here shareholders, right? Shareholders of the company, not less than 85%. They are representing, right? Not less than 85%. And the second condition also to be fulfilled. That is, these shareholders together holding not less than 85% of voting rights. But suppose like this. There are 5 shareholders in the company. Voting power, right? Like A, B, B, E, E. Right? 20%, 20, 50, 5%, 5%, and 5 voting power. Right. A, B, C, E, and E. There are 5 shareholders in each company. Right? A holds 20% of voting right. B 20, C 50, D 5, E 5. Right? Then how this company can sign the written resolution without calling a meeting presentation. So 2 conditions to be fulfilled. Right? The first one is not less than 85% of shareholders per side. And the second condition is they together holding not less than 85% of voting, that same percentage, right? But here, first one with regard to persons, shareholders. Second one with regard to voting power. 85. Doesn't matter, right? 85. Same percentage. First one refers to the person, second one voting power. Right? Without having the consent of E, can this company sign the written resolution? In order to, without calling a meeting, in order to make a particular decision, right? And A, B, C, and D, right? Sign the written resolution. And no problem. Yeah. Right. Yes. Can no problem. Can no problem. Yes. Not less than 85% of voting. Yes, can no harm. Can they sign without calling a meeting? Can this company sign a written resolution, right? Without getting the consent of E shareholder. He refused to sign the resolution. Then can this company sign a written resolution validly in order to make a decision? Yes, no? Can clear? Can't sign a written resolution. Why? Actually, here, all the shareholders must sign the written resolution. Why? They get very different voting right, 95. That's okay. But we have to consider about the shareholders, not less than 85% of shareholders. One shareholder represents 20%, because 500 shareholders in this company. Therefore, as a percentage, they has 20%. So E 20, 20, 20, 20. Right? He refused to sign. Then here, all A, B, C, D, even though all other shareholders signed, right? Altogether, only 80%. 80%. What is the requirement? Not less than 85% of shareholders. 85% of shareholders and not less than 85% of voting power. They can sign a written resolution. Therefore, actually, this company, right, all the shareholders must sign the written resolution. Otherwise, they cannot make any decision. The අවස්ථා දෙකක් තියෙනවා. කොටස් රිවියු කියන ඉතනම යන්නේ පාක්. ඒක තමයි persons. 85% of persons shareholders. Second condition, 85% of voting power. Right? Voting power. So we have to consider the percentage of the shareholders. Persons. Right? That is right. So here 5 persons. So 1 person represents 20. 20. Right? So if he refused to sign, there will be 80%. Right? Not less than. Cannot be less than 85. Right? So not less than 85% of shareholders. Not less than 85% of voting. We can sign. Right? So without getting the consent of E, this company cannot sign the written resolution. Right? Actually, all the shareholders must sign because there are 5 members, 5 shareholders of the company. If the number of shareholders are more than 5, then percentage is decreased. Right? Then actually, even though 1 or 2 shareholders refuse to sign, they can, right? The company can sign written resolution. Percentage is like decreased. Right? Now we are 20. Therefore, without getting the consent of E, right, the company cannot sign a written resolution because 5 shareholders, 1 shareholder represents 20. Right? He refused to sign means, right, only 80%. So this is very difficult, right? Without calling a meeting by way of a resolution, right? Company can make decisions, but because of these 2 conditions, both conditions to be fulfilled at the same time. At the same time, both conditions to be fulfilled. Whether okay or not, instead of and 85% of shareholders own, right? 85% of voting power. So, but the connecting word is important and right. Anytime both conditions to be fulfilled. 85% persons, persons, persons and voting power. 85% of voting. Then the written resolution. They are a couple of special resolution. That without giving not less than 15 working days notice, company can propose and pass a resolution by 85%. 85. 85, 95 on the particular one. 95, that is with regard to EGA. Right? In order to call an EGA by short notice, right? 95% of shareholders must give their preference. Take away from other here, AGM, all the shareholders, 100%. EGM, 5% less. Right? All the shareholders face 100%. AGM with regard to annual general. EGM, short notice 95%. 75, right? If the company unable to give not less than 15 working days notice, then percentage is 85, not 75, right? 85 percentage, right? Will increase, right? Up to 85, not less than 85. By majority of 85% of vote, this resolution to be passed at the general meeting. That's the service. And they will, you know, like leadings and refuge. We have discussed about the unanimous and blameless resolution. Be careful, resolution very important. Consider one these persons, the ability of other person, and ballot papers will have the voting power. Connecting word is and all conditions to be pushed. This is about the witnessing. Another evidence.